Mr. Ivey, you are recognized.
Thank you, Mr. Chairman. With respect to the comments you just made, I refer the chairman and the committee to the actual opinion that was written by Justice Kavanaugh, which is the one that has the force of law, not necessarily the discussion with the Solicitor General Proligar. But on this particular point, the allegation that's being made in the articles of impeachment is that there's a willful defiance of enforcing the law. Justice Kavanaugh, with respect to that point, wrote this: as the district court found, the executive branch does not possess the resources necessary to arrest or remove all of the non-citizens covered by these two statutes. That reality is not an anomaly, it is a constant. For the last 27 years since those statutes were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests. In other words, what he's saying, and this is in the context of the court's reference to cases like Waite, and those are prosecutorial discretion cases. For decades, the Supreme Court has deferred to the executive branch the right to make decisions about what to enforce, what not to enforce, and how to enforce it. And that's exactly what he's saying here. And it's especially powerful here because this deals with enforcement of the immigration laws, which is given special deference to the executive branch. So the language you just read and the article, the first section of the impeachment, are totally negated, not only by this language, but by the long history of the Supreme Court deferring to the executive branch and deciding what to enforce and how to enforce it. And that's exactly what we've got here. I think the argument that Secretary Mayorkas has not enforced these laws, you might not have liked the way he's done it, but I think it's clear in the letter he sent to the committee. And by the way, I thought it was totally appropriate for him to send the letter after the articles of impeachment had been released, since his comments should be related to the articles. But anyway, since May 12, 2023, DHS has removed or returned more than 500,000 individuals. Daily removals and returns are nearly double what they were compared to the pre-pandemic average of 2014 to 2019. I refer to page 2 of his letter, which is dated January 30, 2024. You all can read it and get the rest. But the point is this: the language that you're talking about, as the professor testified, is a total failure to do the job. And the points that she pointed, the issues that she pointed to were things like addiction or, physical inability to perform. We don't have that here. And the language that's in the letter that he sent and the data that's backed up by it show that he's actually been working on the job and doing the work, as done the recognition by the Senate, Democrats and Republicans, who've called him to the Hill to negotiate as they're negotiating a bipartisan solution to the problem. Unfortunately, we haven't done that, but they recognize that he's doing the job. And then the last point I want to make, your reference to—
Gentleman, yield for a question.
I can't because I'm running out of time. The last point I want to raise, though, is that your reference to impeachment being the only tool available, and this is page 14 of the opinion. This is still Justice Kavanaugh. For example, this is where he's talking about options since there's no standing. What can Congress do instead? For example, Congress possesses an array of tools to analyze and influence those policies: oversight, appropriations, the legislative process, and Senate confirmation, and through elections. He does not mention impeachment. In fact, I'm not sure I saw impeachment mentioned anywhere in the opinion that he wrote. And by the way, there's a concurrence from Justice Gorsuch. All 3 of the Trump nominees to the Supreme Court agreed with this language. None of them supported the position that you just outlined. And it was an 8-to-1 decision. The articles of impeachment rely on Justice Alito's language. He's the sole dissenter in this case. So just based on the constitutional law as explained by the Supreme Court in the case that you cited in the article cite, it comes out exactly the opposite and undermines the claims that somebody could be impeached in the executive branch for following executive authority that the Supreme Court recognizes as theirs, especially in immigration cases, and that's been true for decade after decade. I yield back.